We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. These are the opening words of the preamble of the Indian Constitution, affirming that our country is a constitutional democracy, a rule of the people, by the people, and for the people. To give you a simpler definition, which is also given in the Merriam-Webster dictionary, a democracy means a government by the people, especially the rule by the majority. And I want to emphasize on the latter part, that a democracy is the rule of majority, as we commonly perceive, And why not? Whether it is political parties scrambling to get that requisite number of seats to form the government and form the majority, or it is the parliament passing, amending, and repealing several laws based on simple and special majority. The weakening position of the opposition, unfortunately, in our democracy today, is also what contributes to our thinking that democracy is the rule of majority. I stand before you and I contend otherwise. I stand before you and I contend that democracy is not the rule of majority, it is the rule of law. So, what is the rule of law? And why does it matter to all of us? Why does it matter to each one of you sitting over here and me and everyone else outside in India? The rule of law envisages that the Constitution is supreme and all of us are subjects of the Constitution. The law courts and the judiciary protect our fundamental rights under the Constitution. The doctrine of rule of law can be traced back to ancient Greece when Aristotle said that the law must govern and those who are in power must be governed by the law. Sir Edmund Coke, who was the Chief Justice when James I was the King of England, consistently maintained that even the king was subject to law. The doctrine of rule of law in its modern form has been developed by one Professor A.V. Dicey in his monumental treatise, Constitution and Law. The Law and the Constitution. Professor Dicey explained the rule of law in three simple yet interrelated concepts. First is supremacy of the law, that the law is supreme and everyone is bound by it. Second is equality before law, that each of us is bound and has to abide by similar set of laws. And lastly, the predominance of legal spirit, signifying that it is the courts of law that will protect our liberty. So in simple words, the rule of law means that the government officials, as well as the citizens like me and you, will be bound by and will abide by the rule of law. I'll say that again. The rule of law means that the government officials, as well as the citizens, will be bound by and abide the same set of laws. Yet, in 1975, something strange happened, something that led to the citizens questioning the very existence of the rule of law. On 25th June 1975, when the emergency was imposed at the instance of then Prime Minister Mrs. Indira Gandhi, the fundamental rights of all citizens were suspended. Imagine being in such a situation. Article 21 of the Constitution is suspended, which guarantees you right to life and personal liberty. You are jailed without giving any explanation, and you're not even heard, and you're not even entitled to explain yourself as to why you should not be arrested. Hundreds of people were arrested during that time. So what would your expectation be? Based on Dicey's third principle, you would look at the law courts, to protect your fundamental rights. You would look at the courts and say, see, I have a right to life and personal liberty. I cannot be arrested like this under some draconian law called MISA, or the Maintenance of Internal Securities Act. And that is how the matter reached the Supreme Court. And by a 4-to-1 majority, which means 4 judges ruled on one side and 1 was a dissenting opinion, 4-to-1 majority, the Supreme Court held that during an emergency, Article 21 was suspended And because Article 21 was suspended, the rule of law also stood suspended. In other words, rule of law had no separate existence. Shocking, isn't it? I mean, rule of law didn't exist at that point of time when emergency was imposed in the country. However, as I mentioned, one judge, Justice Khanna of the 5-member bench, gave a dissenting opinion and said that if we agree with this majority view, then even the Nazi murders would qualify as law. And that is something which, made the citizens think about the existence of the rule of law in India for the very first time. This controversy was settled, of course, by the 44th Amendment to the Constitution, which said that, Article 21 cannot be suspended even during an emergency. But the threat to the rule of law continues till date. Recently, the Right to Information Act was amended this very year. Right to information, or RTI, is a fundamental right available with each of the citizens. What do you do with that? You seek information from public authorities, and you seek information because it's a constitutional right, correct? It ensures that there is transparency and accountability in governance. But the recent amendment, by trying to control the pay and the tenure of the information commissions under the Act and bringing them under government control, is the first step to weaken this legislation and fundamental right. I must say this with utmost clarity, that if we do not have right to information, we will not have freedom of speech and expression. And if we do not have freedom of speech and expression, the ability to express ourselves, there will be no rule of law. A bill that is pending in the Parliament, the Citizenship Amendment Bill, tries to relax the criteria for citizenship by naturalization. Sounds fine, right? But it says the criteria will only be relaxed for non-Muslims. A direct blow at the secular character of the Constitution, which makes us question, is democracy a rule of majority? Or is there rule of law that is still existing? Rule of law is of utmost importance, and I will fail in my duty if I do not inform you about the positives and the role that the judiciary has played in guarding the Constitution and the rule of law. The best example that I can think of right now is the power of the Parliament to amend the Constitution, correct? The Parliament can amend the Constitution, but it cannot touch the basic structure of the Constitution as held by the Supreme Court in the Keshav Nanda Bharti case. Therefore, a fine balance has been achieved between the legislature and the judiciary in upholding the principles of the Constitution that form the very bedrock of the constitutional democracy and the rule of law. Another bright and shining example of the rule of law would be when the Supreme Court recognized that right to privacy is a fundamental right under the Constitution. Furthermore, when the Supreme Court struck down the draconian Section 377, giving the LGBT community the much deserved dignity and liberty that they had even otherwise, but it had to be recognized by the court, upholding the rule of law. So where are we right now, and where do we go from here? How do we uphold this constitutional value? How do we ensure that our democracy is protected as against the whims and fancies of those who are ruling us currently or in the future? The first thing, of course, would be to ensure that our courts continue to protect our fundamental rights, because they are the guardians of the Constitution ultimately. But it's not only the courts, it's also upon us as citizens to be informed, to make good choices, and to uphold the basic constitutional ethos as well as democratic institutions. A democracy, after all, will thrive only when the constitutional institutions and the democratic institutions thrive. And when these institutions thrive, you can have the rule of law. I therefore submit once again that a democracy is not the rule of majority, but it is the rule of law, and I rest my case with that. Thank you so much.